episode number 3 of Upstate and Litigate. I'm Derek Spada.
I'm John DeGasperis. We are personal injury lawyers. We're partners at the law firm of Basch Keegan in Kingston, New York. We started this podcast to talk about all things that are law. And today we're going to talk about the trial process, and basically the overview of what a trial looks like. And in other episodes, we're going to discuss the various segments of a trial. We are trial lawyers. You know, sometimes people will call and say, well, what kind of lawyer are you? You can call yourself a personal injury lawyer. You can call yourself a civil litigator. But I like to refer to us collectively, the law partners there, and the firm as a trial law firm, or we are trial lawyers. And I think that speaks to our skill set, which is we take each case and prep them for trial from the outset. Although we know that most of them settle before they get to trial.
I like to be called a trial lawyer, but I prefer to be called a settlement lawyer.
Yeah, we are early settlers, right? But
yeah, there's certain cases that you can't settle for whatever reason, and those are the ones that you go to trial on. But I think at our firm, we're ready to go to trial on every case.
We are. But for this conversation, let's say that we've litigated the case. Client says to you, hey, is the case going to settle? And it's one of those weird cases where the insurance company is offering no money. And your client says to you, well, what does a trial look like from start to finish? What are the stages of a trial? The case is behind us. The litigation is behind us. What's the outline of a trial, start to finish? I went to my old trial techniques textbook. Did you have one of these in law school?
I did. I still have that book. I've got the hard copy.
You have hard copy?
It's like a smaller physically, but I've got the hard copy of Thomas Mallett. Yeah.
Yeah. If you take any trial practice class in law school, usually you have to get a trial techniques textbook. So I went to the table of contents, and the first section is the trial process, which is what we're discussing today. And it does give you this interesting skeletal outline. And, it really does hit everything. So you have local practices and procedures. You have trial date assignment, jury selection, as you were discussing. You have preliminary instructions of law, opening statements, plaintiff's case in chief, motions after plaintiff rests, defendant's case in chief, motions after the defendant rests, plaintiff's rebuttal and defendant's surrebuttal, motions at the close of all evidence. You have an instructions conference, closing arguments, jury instructions, jury deliberations and verdict, post-trial motions and appeal, and then you have a conclusion. And what I find interesting is that when you prep for trial, you have to be prepared for all stages and at the beginning. So you have to go to trial and be ready for the beginning, the middle, and the end.
Yeah.
But take, for example, something as simple as local practices and procedures. If you go from Ulster County to Dutchess County, just across the river, the trial practice is different.
So, it's a whole different ballgame over there.
It's different.
And you can see it from here. If you go to the Hudson River bank, look across the river, it's like you look over there, it's like a half mile away or wherever it is.
Yeah.
And it's a whole different trial practice. Yeah.
Different trial practice. For example, in Ulster County, you always try your personal injury cases in one trial, meaning you'll try the issues of liability and damages in one trial. You go right across the river to the neighboring or adjacent county, and they have what we call bifurcated trials, which is what?
That's where you try liability first as a trial by itself, meaning who's responsible for the accident. And then if you win as a plaintiff, then you go on to a damages trial.
Right. And I think it's interesting for any young lawyers out there or people contemplating going to law school or maybe in law school is if you're going to be a trial lawyer, you have to be aware of venue, local practices, the judiciary in the respective geographic regions and jurisdictions. And I think it's really interesting. Now, I think New York State does try to have some sort of uniform rules. In fact, they're called the Uniform Trial Court Rules. But each judicial department or jurisdiction is allowed to have its own nuances, and they certainly do. Then you have things like the trial date assignment. A lot of our clients, I don't think, appreciate that once you're done litigating a case, you ask the court for a trial date, and then they give you this trial date that's at these days, 8, 9, 10, 11, 12 months down the road.
Yeah. The courts were fairly well caught up before COVID, but then things went off the rails there.
I think the huge gap in time between when you conclude the discovery process and get your trial date is one of the most disheartening things about being a plaintiff's personal injury lawyer. To tell your client, hey, I know we've been doing this for a year and a half, and great news, you have your trial date. It's 10 months down the road.
Next year.
And meanwhile, the case sits virtually dormant during that time.
Yeah.
Yeah, so that sucks in my opinion. So then you got jury selection. Picking a jury, depending on the complexity of the case and the facts of the case, could take you 2 hours. Yeah. It could take you, me, I'm usually long. I usually take 2 days for a simple case. And we may have talked about this before. I think we disagree on this, but I think jury selection is the most important part of the trial. What do you think?
It's right up there. I mean, if your jury's not good, you can still do a great job and, get a better result. But I found with my past trials more recently, I've been shooting for younger jurors.
Yeah, we've talked about that.
Yeah.
I don't think there's any one set rule, and why do you like younger jurors right now? I think we agree about this point.
There's several reasons, but I just find that younger people they seem to be more open-minded, whereas people who are older are more set in their ways, more set in their views. And people who are younger understand how much things cost. They've gone to college. If you find someone who's younger in college, educated in their 20s, if they went to a private school, they spent $60,000 or $70,000 a year for college, whereas someone who's 75 years old maybe went to college but spent $4,000 a year for college.
Sure.
And there's such a great disparity that younger people understand economics as they apply to today's world much better than people who just lived in a different era.
I also think that you could take the same case to 10 different juries and get different outcomes.
Oh, yeah.
And I think the best jury for you as a lawyer may not be the best jury for me as a lawyer, right? Because we connect with people on different levels and we have different styles and mannerisms. And I think all of those things play into the jury that you pick. So, Derek Spada is going to pick a different jury for his case than John DeGasperis would. Doesn't mean one is better than the other. It's just stylistically, it's how you connect with people and talk to them. Now, there's another thing though, jury selection that is conducted differently in each county, right? I mean, there are similarities, but my experience picking the jury in Orange County for that product liability case I tried recently was dramatically different than my experience picking a jury in Ulster and Dutchess County. And so I think again, you go back to each venue or jurisdiction has different practices, and they have, strikes method and white method. These are all different ways of using your preemptory challenges and the order in which you pick and rotate. So I think, these nuances that you have to learn and you have to understand if you're going to be a trial lawyer. You have to be flexible and be able to pivot. So, the next thing is preliminary instructions of law. So for our viewers, you have your trial date. Mm-hmm. You know where you're trying it. You show up for day one. You pick your jury. You have your jury, and now your trial's about to begin. The judge takes the bench and gives preliminary instructions of law. So tell the jury what happens there, or tell our viewers what happens there.
Well, jurors, what happens there is the judge tells the jurors these initial instructions about what they're supposed to do as jurors during the trial. And they're pretty basic instructions, but it's things like, I say that the most important rule is not doing outside research about the case or talking to each other or other people about the trial. So if you go home and tell your friends or family or whoever that, I'm on this jury, and then you mention even some basic information about the case, the person who you're talking to may say something one way or another, like, oh, the person's probably totally lying about it, or the person deserves $5 million, or somewhere in between. But those comments can influence jurors, and that's not supposed to happen. You're supposed to be like in this bubble. I tell the jurors.
That's really interesting to hear you say that that's the most important rule, because I agree with you, but I don't think I've ever thought about it like that. So do you talk to the jury about that?
Yeah, in opening statements, I tell every juror, or actually during a jury selection, I tell every juror that if you're chosen as jurors here, as much as you want to talk about this trial while it's going on, or you go home to your spouse, and your spouse says, "Hey, how was court today?" You can say, "Oh, it went well," but that's about it. You can't go into details.
Yeah.
And your spouse may really want to hear about it, but
it's inappropriate. You're not.
You just can't talk about it, and it's frustrating. It's hard. It's like having, it's just like this, being tempted to talk about it with someone who's very close to you, the closest person to you in your life. And you just can't do it while the trial's going on, because
you can do it later.
Once the trial's over, you can talk to everybody about it.
So I think one of the most important preliminary instructions that a judge gives to the jury is don't talk to the lawyers, and the lawyers are not going to speak to you in the hallway or on an elevator, and may not say even a basic hello or goodbye. And I always try to remind the jury about that rule during jury selection as well, because these courthouses are small, and you get stuck on an elevator, and all of a sudden you're like jumping off when a juror gets on. You better tell them, hey, it's not that I think you have cooties, I'm just not supposed to be alone with you.
That happened once to me when I was I was in the elevator, and I walked in, I pressed the button to go to whichever floor I was going to, and I walked to the far end of the elevator. And when you're in there, you can't, if someone comes, they can't see that you're in there because you're like a little hidden. So as the doors began to close, 2 jurors jumped on the elevator, and I was like, oh no. And then I was just looking around like, well, I'll look at the floor, and the doors were shut. Now we're stuck in the elevator. I'm like, what do I do? Yeah. And of course the door opens, and the other lawyer is standing right there. I'm like, hi.
Yeah. I mean, most people are cool about that kind of thing, but you certainly don't want to get caught talking to a juror. But yeah, I mean, the preliminary instructions, I think you're right. The judge gives the jury a set of rules by which they are supposed to operate. I think sometimes you'll hear the judge give the jury a basic understanding of how the case will be presented, like in what order and manner, and some basic rules of evidence or things like that. Then once the judge gives preliminary instructions of law, what happens next?
Well, then the next step is opening statements. So that's when each side says their opening statement. Where I feel like as a lawyer, you have to be careful with what you say. You can't overstate your case in your opening statement.
Sure, you got
because you can say things that you're going to prove during the trial, and then if you can't prove those things, you've promised and didn't deliver.
And you're not supposed to argue. You're supposed to set forth the facts. A good lawyer does argue, in my opinion.
Yeah.
You have to be subtle about it and weave it in.
The trick is if you preface it by saying the evidence will show,
right?
Then you can say whatever you want after that.
Whatever you want,
which sounds ridiculous, but that's how it works.
My last trial, the lawyer objected, and we had the sidebar after the first sentence of my opening statement. Had the sidebar after the first sentence of my opening statement. But I got my point across, because you're not supposed to make policy implications, right? Like my opening line was, your verdict in this case will change the world, basically, and apparently you're not supposed to do that. Yeah, so this is something that I learned less than a year ago. So I'm like 12 years into practice, and I learned that your case can be dismissed if during your opening statement you don't satisfy all of the elements of the case. Did you know that?
Yeah, I've heard of that before, but I've never actually seen anybody enforce it. Right,
it happened to me. I mean, except thank God I was the criminal. It was in a criminal case. I was the criminal defense lawyer, and the case got dismissed after the prosecution gave their opening statement, and in the opening statement neglected to discuss a critical element of the charge, and the case gets dismissed. But the same rule applies in personal injury cases. If the plaintiff's personal injury lawyer does not address every element of the cause of action in the opening statement, the case can be dismissed. You're allowed to amend or supplement your opening statement, like if there's a sidebar and you realize it didn't happen, but you have to do it.
Yeah.
Yep. Now, typically, like a judge will give some type of restriction about how long your opening statement can be. There's, depending on who your judge is and what you've discussed in advance of the trial, you may be able to show evidence during an opening statement. Have you ever done that?
I have.
I have.
Yeah, I have.
I have.
Yeah.
But that's usually, it's got to be done through a stipulation. You have to stipulate to the evidence or something. But, so stylistically, the opening statements can vary, but usually you don't want to bore the jury too much, and you introduce the facts of the case. Who goes first?
Plaintiff goes first.
All right. I don't know about you, but like on opening statements, do you still wonder who goes first? Come on. Is there just like a hesitation?
There's a very slight hesitation.
First?
Yeah. There was one trial I did like some years back with a relatively new judge, and he the judge asked the defense attorney to go first.
The judge
and,
does it.
The judge
screws it up.
The judge said, "Mr. The defense attorney's name. Go ahead with your opening statement." And the defense lawyer sat there for a moment. I was like, "Well, I'm ready to go, Judge, but he goes first." Pointing at me, and I was like, "Oh, yes, yeah, Judge, I'm ready to go." So,
but wait,
anyway.
Now I'm confused. I thought we go first.
We go first in openings. Plaintiff goes first in openings.
Yeah.
But then in summations, closings at the end,
we go.
The defense goes first. Plaintiff goes last.
Yeah.
So it flips at the end of the case.
All right, and then here's one other thing: when you walk into the courtroom and you can go to the table on the left or the table on the right, are you like?
I know. Yeah. The trick there is you sit by the jury box. So the plaintiff.
Is that right?
Yeah, the plaintiff sits closer to the jury.
Okay. Always gets me.
Yeah.
Always gets me. All right. So then after opening statements, you have the plaintiff's case in chief, and that's when the plaintiff puts on his or her show. That could be witnesses, evidence, expert witnesses. But during this presentation, the defense attorney gets to say something, right? They get to object, they get to cross-examine. But essentially, the plaintiff presents his or her case first in its entirety, right?
Yep.
And then what happens when the plaintiff is all done? What do they say?
The plaintiff rests.
Right. Now, what happens after the plaintiff rests?
Then the defense attorney typically gets up and makes some nonsensical motion to have the case dismissed.
That's outside of the earshot of the jury.
Yeah.
The judge will ask the jury to step out or sequester the jury. They don't hear the application, but the defense attorney makes an oral application to the court, essentially argues that the plaintiff
that they didn't meet their burden of proof, and the evidence is insufficient for the plaintiff to win, something like that.
And that type of motion, it can be granted, but it's rare.
Yeah, I don't think I've ever had that granted. The judge will.
Didn't you have it on the product liability case that where your expert wouldn't do?
That's right. Yeah, the expert wouldn't come to court after.
Right, so it does happen, but it happens.
Yeah.
That's like a very rare experience.
Yeah. It was
and your expert bailed on you. So it was like,
the expert led me along through the whole case, looked at the product. It was still a tough case, but it's something to work with.
Right.
And then it came time for trial, and the guy just wouldn't come to court.
Yeah, you can't win a product liability case without an expert.
No.
So, all right. Now, the application by the defense attorney is denied. What happens next?
Well, after that, then the defense presents their case.
Okay,
and
so they have an opportunity to present their own evidence anew.
Right.
Right. And that's when they would call their expert.
Yep, their expert, their client, whoever they want to have testify, they present their evidence.
Right, yeah. And then they rest.
Right.
And then the plaintiff can ask for what we call directed verdict.
Yep.
That means I've proven my case. I've satisfied all of the elements. There's no question about it. We don't need the jury to decide it. As a matter of law, Judge, you can establish it now, right?
Yeah.
And that happens too.
Yeah, but occasionally, that happens if the defense basically has no defense or very minimal defense to the case, and it's clear that the plaintiff should win based on the facts and the law.
Right. And then after the defendant rests and the plaintiff makes the request for a directed verdict, in theory, the plaintiff can come back, right, and put on more evidence.
Yeah, you have a chance to do rebuttal, but you can only rebut a certain point or issue or statement that was made by the defense, one of their witnesses, along the way.
Right.
So you can't come back and bring up new evidence in your rebuttal.
Yeah.
You can only rebut what was said during the defense case.
Right. And that's why you have to be careful when the judge asks, does the plaintiff rest? You better be damn sure you got all your proof in.
That's the end for you. When you rest, you can't go back and say, hey, hang on a second, can I unrest?
Yes, right. Yeah. No, so I don't know about you, but I usually ask for some time. Yeah. You know, usually you and I these days are trying our cases with our paralegals there, and like we have a conversation. Did we get it? Did we get in? Exhibits A, B, C? Did our witness say what they got to say? Because you, in theory, before you rest, could ask for permission to call back a witness, right? Yeah. So you got to make sure that you have proven all of the essential elements before you rest, because that's a moment. That's a moment in a trial. So plaintiff rests, defendant rests, oral applications are made. Let's assume there's rebuttal or no rebuttal, whatever you want, but it's done. Then what happens? The judge charges the jury, right? Oh, yeah. No, but before that, you meet with the judge. Before the jury deliberates, you have a charge conference with the judge. So tell the viewers what happens at the charge conference.
At the charge conference, we have these pattern jury instruction books, which have all sorts of jury charges in them or instructions.
It's essentially the law. It is the law of the state. It's the law of the state. Called a pattern jury instruction.
And it's stated in a way that that regular people would understand it. So it's right. The law, but put in more or less plain language. I feel that we as attorneys, pour over this and we go back and forth about which charges should be read to the jurors. I feel like by the end of the trial, most jurors are done. Like they've already got their mind made up, and they don't listen to about 3/4 of what the judge says at the end of the case. But that's my take on it. There's a few charges in there where in my summation, I'll tell the jurors to pay attention closely to when the judge tells you about something, for example, like the definition of negligence, or I'll pick out one charge that I know is going to be read to them, and then when the jurors do hear those words, they tend to perk up. But otherwise, they've been there for the better part of a week. They don't want to hear this nonsense.
Yeah, and the charge conference, I mean, some are easier than others, but some can be really intense. And what you're doing is, on some occasions, you're taking the law of our state, right? Like negligence defined, or whatever the issue may be, because the rules of evidence are highlighted in the pattern jury instructions, and inferences that the jurors are allowed to make, and all of these different things. But you're sometimes manipulating what's written in the book to apply to the facts of your case. And that could be a very interesting process. And depending on whether the judge adopts your version of how you would like these things stated, it could alter the outcome of the case. I think you're right. By then, they've made their mind up. But for those who are disciplined and will not make their decision until they hear the law, how you craft these pattern jury instructions can be critically important. I tend to reference them during my closing. So I'll hold the book and I'll say, as you're saying, if something's critical, I'll read it. I'll say, you got to listen to this one part, and I'll say, this is the law of our state. And I think it's worked. It works. I've had situations where the court officers after the fact will be like, I think when you did that changed it. Or that was the moment.
Also the verdict sheet, you have to agree on the verdict sheet.
Oh, the verdict sheet. Okay. So you're right. That happens during the charge conference usually. But you know what's interesting about the verdict sheet, and I'll have you define, tell the viewers what that is. But if you know your verdict sheet, that's what you have to prove, right? So if oftentimes you have to submit that in advance of the trial, it may change, but when you submit it in advance of the trial, you know what you have to prove. The jury is going to be asked a series of questions, and that's your mission. But so what is the verdict sheet?
They're questions that the jurors have to answer at the end of the case. And based on the case, it could be a shorter or longer verdict sheet based on how complex your case is. But they have to decide things like, was the defendant negligent? Was that negligence a substantial factor in the plaintiff's injury? Also, was the plaintiff negligent? Was the plaintiff's negligence a substantial factor in causing the injury? And then they would put a value on the case, more or less. There's more steps than that. But what I do in my closing statements is I take that verdict sheet and I hold it up and I go through question by question.
I do.
And
Most
explain,
often, not always, but
I explain why the jurors should answer those questions in my client's favor.
Yeah. It's a nice way to outline your overall argument.
And then the jurors know what they're doing at least, and they're they don't maybe agree with you every time, but at least they know what they're doing. There's this verdict sheet that's not totally foreign to them.
But what's interesting is depending on the type of trial and the facts of the trial, the jury could be answering 2 questions or maybe 17.
Yeah.
It's really interesting. And the longer your verdict sheet, the longer you're going to wait. And, how about this moment? Jury comes out. So we'll move on. So you do your charge conference. You've agreed to the verdict sheet. Then what happens? The judge brings the jury back in.
Yeah.
And does what?
Well, then gives I guess at that point, that comes typically before your closing argument.
Oh, right.
So then you do your closing argument, but then after that, then the judge reads those instructions that you've agreed upon to the jurors.
Right. But you're right. We agree on the law, we agree on the verdict sheet, and then you give your closing remarks.
Yeah.
Yeah. Now, I think by the time you give your closing remarks, they've mostly made up their minds.
Yeah.
But you got to give a killer closing.
Yeah, there's been some trials that I feel I'm really confident that I won during my closing argument.
I know that I won them on my
and you have to really connect the dots together.
I think closing's more important than opening.
Oh, definitely. Yeah.
I think closing's more important than opening.
Yeah. And then after the closing, the judge gives the jurors those jury instructions and discharges the jurors back to their room. There's 2 alternate jurors. So out of the pool of 8 jurors who sat through the whole trial, 2 names are picked out of a bin or a hat or whatever, and those people are sent on their way.
They're called non-designated. So they sit during the trial as if they know that 2 people are getting cut, basically, but they don't know who's getting cut. So they all got to focus, and then at the end, you cut 2 people. Now, but again, that varies based on jurisdiction. So you can go to some courts and they use designated alternates. So the alternates know at the end they're out. I don't like that.
Right, because then they don't want to pay attention and they feel like they're there for the whole week.
And they just feel less important.
Yeah.
But, and what's crazy is I think a good judge holds the alternates.
Yeah.
At some point you can let them rip. But all right, so you give your closing remarks. Then what happens?
Well, after your closing remarks, the judge will do the jury instructions, dismiss or set aside the 2 alternate jurors, and then send the jurors into a room to deliberate and come up with a verdict.
Yep. Now, going back to that verdict sheet. So now the jury can ask questions, can ask for clarifications of law, can ask to see evidence, can ask to hear testimony read back. They can ask questions about their responsibilities, right? All these different things. And they do that by note in writing.
Yep.
But let's assume the jury's got their verdict. And now you had one of those long, 15 question verdict sheets. One of the worst feelings in the world is when the judge doesn't keep flipping because you know that they didn't get deep into the verdict. But when the judge is reading and he or she's on page 13 of 15, you know you got it. You got something.
And then when the judge's eyes get big, you know, like you really hit it.
Oh, that's a good feeling. Yeah. So there you go. That's the overall process. Some trials are really short. Some trials take a really long time. We can take breaks, right? We break for lunch. You could take days off. You could try a case on a Monday and a Tuesday and take a break and come back on a Thursday. There's no set approach to that. These days, it's I think a good idea to be cordial with the defense attorney. You could take witnesses out of order. You try to play nice to get the case in and get it in efficiently, because in my opinion, you want to keep those jurors happy and you don't want to keep them waiting.
Yeah.
I don't think it works to the plaintiff's advantage to delay the resolution. I think one of the key things that jurors are evaluating is your preparedness, your readiness, and, do you help move the case along and put in the proof? Because I can't, I think jurors punish lawyers who are like, Judge, my witness isn't ready. Can we have a 2-hour break? I think that drives jurors nuts.
Yeah.
So, all right. Well, I think that was a was a good overview of the overall trial process. I think in upcoming shows we should break down each segment and talk about each segment in greater detail. So maybe next time we'll talk about jury selection, the various ways that jury selection is performed, the things that you and I like to do to pick a good jury, and things we think about and do to pick the best juries for our cases. All right, Derek, big question for you here.
Yep.
How long does a personal injury trial take? Not the case, but just the trial.
I don't know. It really depends on the case. Some trials can actually be done in one day, and some take a matter of weeks. But on average, between 3 to 5 days.
Derek, you just tried a case the other day for an hour.
I did. That was the shortest personal injury trial of my life.
It was literally tried a case in an hour. That was a bench trial, was not a jury trial, so they move quicker and the judges just accept evidence. But you got a trial done in an hour.
I did, yeah. It was a non-jury trial, so it was only with a judge, and there was no defense whatsoever. I had my client. He testified for about 45 minutes or so. I put documents and other things in evidence.
There you go.
That was it.
That was the murder she wrote.
Yeah.
Some trials can take many, many weeks. Those are obviously your more complicated cases. The Johnny Depp trial, for example. What'd that run? 3 or 4 weeks?
No, that was more of a fiasco than a trial.
That's true. That's true. No, but I agree with you. Your average personal injury case, your car accidents, your falls, 3 to 5 days.
Yeah. John, what are the main differences between a criminal trial and personal injury trial?
There are many distinctions. I think the primary distinction is that in criminal trials, the government, on behalf of the people, prosecutes the case against the accused. In a personal injury trial, the injured plaintiff prosecutes the case, brings the case forward against the defendant, the negligent party. So you have burden of proof differences. In a criminal case, the prosecution is obligated to prove their case beyond a reasonable doubt. That is an extremely heavy burden, very difficult task, and that is because somebody's liberty is on the line. And as the people, we want the prosecution to have a very difficult time taking someone's liberty away. Now, in a personal injury trial, the plaintiff has the burden of proof. Their burden is to show by a preponderance of the evidence that their version of the story is more likely the truth. It's a much lower burden of proof in a civil trial as compared to a criminal trial. The size of the jury is there's a major difference in the size of the jury. Your criminal trials, felony level, you have 12 jurors, and in a personal injury trial, you have 6 jurors who deliberate. And there are many other distinctions as well, but those are your 3 primaries. So the 3 primary differences between a criminal trial and a civil jury trial are who's prosecuting the case, the burden of proof, and the size of your jury.
All right.
Oh, all right. There are a lot of great restaurants out there, and times are changing here in Ulster County because there's a lot of new stuff. But I'm a huge fan of La Canard. I love the ambiance. I like the food. I like the servers and the service. I like that it's in Uptown Kingston. And I'll also just say, is if I can, have a secondary option, I really like Annarella's out in Saugerties.
Yeah.
So those are my 2. Those are the restaurants that I would pick if asked to go out to dinner in Ulster County.
Well, those are two of the best around, I think, John. Yeah, I feel like with La Canard, it takes you somewhere else too. Like when you walk in there, you're not in Kingston anymore. You go in there and you're in Paris.
I agree.
It feels like, and Anarella, you're in someone's house there, so you don't really, that doesn't necessarily take you somewhere. But that food is real, authentic Italian food. It's as good as it gets. So those
they have a very nice
best
dining room there too.
They do, yeah. Those are definitely 2 of my favorites. I've got a bunch of favorites, but I'm gonna go with N-Cut down in West Park.
Really?
Yeah.
I like N-Cut.
Yeah,
There's
I feel like
great restaurant.
I feel like you can go
there. I just
there.
didn't know I was going to get that from you right now.
Yeah, I feel like if I go out to a restaurant, I almost never order steak or a beef option on the menu because I feel like I can typically make that at home.
I don't get steak
Just as well.
either.
But at End Cut, the steak I've gotten there is better than I can make it at home.
All right, Derek. Well, great episode of Upstate and Litigate, talking about the trial process. Thank you, everybody, for listening. We're having a blast doing this.
Yeah, thanks for tuning in. We hope you found it interesting and at least somewhat enjoyable. And tune in next time. It'll be even more fun.
All right, we're signing off, and our next episode will be medical malpractice.
See you next time.